Well, again, good morning, everyone. Marc from Verve Group. Have a special guest today. Eddie Griffith from ReGroup Solutions is joining me today because, as part of the economic response to the coronavirus, the federal government has intimated that they will relax the insolvency and bankruptcy laws that govern our land. So there's a bit in it there for directors of companies, and that's why we've brought in our insolvency expert, Eddie Griffith, and he's going to take us through these in a bit more detail. So welcome, Eddie. Thanks for joining us.
Thank you, Mark, and thanks for the opportunity to discuss the COVID crisis.
Yes, it's been amazing. It's been the world is upside down, so we're all here to try and make some sense of it and make the best of it. So I guess in terms of these bankruptcy and insolvency rules, I understand there's a few elements to the package, and we've got 4 of them, which I will bring up on the screen for people to see. So Eddie, there's the 4 dot points, and I guess the first one's in relation to what creditors can do to you. So can you perhaps take us through that one a bit more?
So effectively, what the government's looking to do here overall, they're trying to put in place legislation that gives the directors of companies time to just suspend trading and effectively batten down the hatches just to try and avoid going into liquidation or insolvency.
Yeah.
That's the overarching sort of drive of these changes. So on Sunday we heard that the pubs, clubs, bars are being closed, and then immediately that would have a knock-on effect. The first thing that would happen in these situations, because there's a risk to cash flow, creditors are going to start chasing their money pretty hard. Yeah. And that's why they've looked at statutory demands. So in normal circumstances, you need to be owed, depending on the situation, you need to, whether it's corporate or personal, you need to be owed $2,000 or $5,000 to pursue a debtor under a statutory demand, and they've increased that amount to $20,000, which is quite a large jump, but not an enormous jump, I should say. Then probably the more important change there is actually on the date by which the debtor has to respond. So as a creditor, if you issue a statutory demand, usually we would require a response within 21 days. They've changed that now to 6 months. And so the federal government has effectively put a date on this where they're basically saying that for 6 months, we want businesses to survive, however that might be. We want to try and survive, not appoint a liquidator, if possible. And also they're trying to just prevent companies from unnecessarily going under.
Yeah.
So that's the first 2, and the effect of that will simply be that you can't be pursued you can't be pursued very easily into an insolvency event. Yeah. There are other routes, but this one in particular, this one is targeted at those creditors that would aggressively pursue you normally. They now can't do that. So you've got some breathing space.
Yeah, I think that's the point the government's trying to make, isn't it? They want businesses to know that they can still do a bit of business, and they're not going to have people chasing them for money. And so, yeah, they've increased the amount that you have to owe. And if you do get a demand, well, you've got instead of 21 days, 6 months now to respond. So yeah, pretty much putting all of this chasing of money to bed until we see the other side of the coronavirus.
Yeah, that's right. That's right. One thing it is worth just noting, if you have received, so they announced it on Sunday. It's only just the bill was passed 2 days ago, and it was set to become effective the day after royal assent. So one thing to just be careful of is to make sure that you haven't received a statutory demand in those few days since Sunday, because I have had a few clients where they've had very keen solicitors quickly get a statutory demand issued.
Yeah.
The 21-day limit would still apply in that particular circumstance.
Yeah. All right. Thanks, Eddie. On that one, the next one's about relief for directors from personal liability for trading while insolvent. I think this is a pretty big one. Is that right?
That's a big one. And actually, I'll probably just jump to the fourth one, because that's a quicker one to deal with.
Okay.
In that, what's effectively been happened, the Treasury has basically been given some flexibility to adjust the Corporations Act, just as they have here with the statutory demand. They're putting in place flexibility. So based on how this this coronavirus plays out, they can put in place various changes to the Corporations Act as they see fit. So unforeseen events, something crops up, they can now move quickly to put in place measures to deal with certain parts of the Corporations Act to try and help businesses. And that could be things like stay on rents, things like that. So yeah, coming back to the probably the main one, which it sounds good, but it needs to be explained. So the temporary relief for directors from personal liability for trading whilst insolvent. So in effect, directors have a duty to make sure they're not trading insolvent. And if they do trade insolvent, they can be held personally liable for the debts that they incur during that time. So there's other routes by which you can be made personally liable for a company's debts. The ATO can issue a director's penalty notice in respect of superannuation, pay as you go, and now GST as well from the 1st of April.
Right.
Now they're saying that they're going to hold off on that those particular recovery actions in certain, in the circumstances where you're talking to the ATO. So maybe not too much to be concerned about. They are looking to relax the action taken by the ATO. The main one, I suppose, is personal guarantees that people will have given to suppliers and lease agreements, things like that. The fact is, they can still cause you considerable headache. The equipment can theoretically still be repossessed, so need to be a bit mindful of that. Whether or not landlords, the rules in place, a landlord can still lock your premises, and that would cause you significant problems in terms of trading. So you might need to, it's difficult to sort of take legal action against someone like that, because he holds all the cards, having put a lock on the premises. So there's other things. So really, insolvent trading, when it comes to SMEs, small and family businesses, it's not an awful threat, really. It's not directors. I don't find that it's directors' primary concern. Personal liability that might come out of that. So what the government's done, they've introduced what they call a COVID-19 safe harbour. There already exists in the legislation since 2017 a safe harbour whereby directors, subject to certain thresholds, directors can already seek protection from insolvent trading, personal liability. And that safe harbour is still in place, it's still available. The purpose of the COVID-19 safe harbour, the one that's just come into effect, that one the purpose of it is purely for survival, continuation of the business, and for building resilience. So it gives you a little bit of breathing space to effectively work out what your next move is going to be. It's temporary. It lasts for 6 months. It applies to directors, and it only applies in respect of debts that are directly incurred in the ordinary course of business. And there's a bit of ambiguity around that particular comment there, ordinary course of business, because rescue finance, for example, it's still not entirely clear whether that would fall into that bracket. However, directors still have access to the 2017 safe harbour. This one carries a bit more weight. It can protect directors. It can now protect officers, and it also protects advisors. Those that are advising companies that are in financial distress. If there is a sale to be made and an advisor is involved, an advisor can now be held liable under the new phoenixing legislation that came out in February. One of the good things about safe harbour is it's been included as a defence for illegal phoenix activity, or even any transaction that might be challenged by a liquidator at a later stage. So in terms of protection, as I mentioned, same as the COVID safe harbour, protects from insolvent trading, personal liability, and also illegal phoenix activity.
Yep.
In terms of actual debts, it's got a broader category. It protects you from debts directly or indirectly incurred with a course of action that leads to a better outcome. So pretty much all that means is if it's in the best interests of the creditors, then you are able to incur a debt, and you will not be made personally liable for that debt, provided you're trying to get a better outcome for the company.
Yep.
Now, you don't have to actually get a better outcome. It's a point in time assessment. You just have to reasonably believe at that point in time what you're doing is in the best interest of creditors. So we've got the COVID safe harbour, that time frame 6 months. It's there to pretty much enable businesses to temporarily survive. It's so that businesses don't fold immediately. The 2017 safe harbour, that can actually go on indefinitely, depending on what the course of action is. And it's more designed for restructuring, turnaround, and growth. So it looks to me like the government's intention here is to provide that temporary relief, just to give directors immediate breathing space to assess their options. And then the way it's been commented on, it seems to be that the intention is that if they are going to continue trading, if they are able to do that, then they would need to perhaps seek to put in place the 2017 safe harbour, as they near the end of that 6-month term. And the thing is, anyone who's seeking to rely on this safe harbour should really be asking themselves, do they know, in all honesty, do they know they can survive after 6 months in this current climate? Yeah. And I think that would be impossible for anyone to answer at this stage. So the thing is, really, you can rely on this temporary safe harbour if you want to put in place some form of restructuring plan. Look at all sorts of ideas that could potentially salvage a viable business model. Then you need to look at the 2017 safe harbour, because it provides a much broader protection for you, and it gives you more options. So that was that's just really the commentary. They did give a couple of examples of the type of debts that you might directly incur in the ordinary course of business, because it is a bit ambiguous, as I say. So in the commentary for the legislation, the two examples they've given is the type of debts that you might incur if you are to continue employing staff. So ATO debts, that type of stuff. And then the other one is they gave an example of if you were to move your business online and you were to incur debts, then those debts would actually be covered under the COVID safe harbour as well. So that's really the absolute latest of where they're up to with the with this legislation. It's I think it's just kicked in, and they've only just expanded this to sort of give some real explanation behind what it's supposed to mean for people. A lot of advisors are still trying to digest how this is actually going to play out, because in reality, most people aren't going to be deliberately looking to rely on anything right now. Their priority is going to be to protect their own personal position, work out whether they can actually trade through this cash flow wise, and they need to, in the first instance, people need to be talking to their advisors, particularly about cash flow, and the other benefits that might be available under the government incentives, the government crisis plan.
No, you're right, Eddie. I think if any directors of companies out there that are worried about their personal liabilities, they should certainly get in touch with either Verve Group, and if need be, Verve Group will we can bring you in, Eddie, and we can assist our clients in relation to all matters of insolvency and bankruptcy and personal liability. So, is in wrapping up, Eddie, anything you want to add to all of that?
I think just from a broader perspective, the thing is, if a company was struggling beforehand, and if they were struggling beforehand and they're wondering what to do now, then I think they very urgently need to seek advice, professional advice, and act immediately. So the worst thing the thing that we see all the time is that people come forward too late. So if anyone hasn't jumped on single touch payroll yet, has superannuation debt, there's the amnesty that's out there at the moment. The ATO at the moment is probably going to be the most reasonable they've ever been in quite a while. So if you had problems before, use this as an opportunity to come forward, ask for help, and look at your options. It's this is going to flush a lot of businesses out of the woodwork that were potentially struggling beforehand. So definitely worth seeking advice sooner rather than later.
Yeah, I agree with Eddie. Now's the time to seek advice, because yes, we'll never have the ATO in a more receptive mood than what they are now. Eddie, thank you for joining me today, and appreciate your comments and your insights. Hope people in Alice Springs and Adelaide that are clients of Verve's who read this get something out of it. And just want to say, if anyone's got any concerns in relation to this area, please give us a ring at Verve Group, and when we need to, we can bring Eddie in and to give some specialist advice. Thanks again, Eddie.
No worries. Thank you, Mark.
Talk soon.
Cheers. Thanks.
Bye.